This is a remote workshop in case number 25-1253 INV, the Commission's investigation regarding decommissioning financial assurances. My name is Steph Hoffman. I'm the General Counsel at the Vermont Public Utility Commission. Wes Skidmore, staff attorney at the Commission, is also attending the workshop today. The Commission is recording this workshop and a Teams-generated transcript will be created. If anyone on this call intends to record the hearing themselves via video or audio, please indicate that when you introduce yourself. I'll start by having each participant on the call introduce themselves, and we'll begin with Attorney Swain.
Thank you. I'm Michael Swain here from the Department of Public Service in the PA Division, and join me is Scott Wheeler from Finance.
Thank you. Attorney Mullet.
Yes, thank you. David Mullet, General Counsel, All Earth Renewables.
Mr. Dowds.
Jonathan Dowds, Renewable Energy Vermont.
And Mr. LePage.
Good afternoon, Matthew Lepage, representing Green Mountain Power.
Thank you so much. First, we will begin by reviewing a few brief procedures regarding remote workshops at the Commission. Participants may raise concerns with these procedures now or at any point during the workshop if you're having difficulties participating. To facilitate this remote workshop and minimize unexpected interruptions, we ask that anyone who wishes to speak turn on your camera while you're speaking at a minimum, and if possible, keep your camera on during the entire workshop itself if you intend on engaging actively throughout. Anyone who plans to just listen to the workshop can turn your camera off. Commission staff will not mute anyone's microphone, so please keep yourself on mute unless you are speaking. And then to indicate if you want to speak, you can unmute your microphone. Click the button that's the open palm hand at the top that says raise underneath it on Teams, or periodically I'll ask for any comments and feedback. You can feel free to chime in at that time. It's very important that we try to avoid talking over one another. If your internet connection cuts out, please try to rejoin the Teams call or call in via the phone number that was provided in the workshop notice memo. If you're unable to call or rejoin, notify the clerk's office via email or phone, and we'll try to resolve the issue. Does anyone have any questions or concerns about those procedures? All right. With that covered, we'll begin the substantive portion of this workshop. Earlier in this proceeding, the Commission provided draft statutory language and more recently a conceptual plan related to how contributions to a proposed decommissioning fund could be calculated. The conceptual plan was in response to comments we received from several participants in this proceeding regarding how contributions would be calculated and what the parameters for participation in the fund might be. What we plan to cover today at the workshop is to go over a brief overview of why the change is being proposed and some of the goals of the new model that is being investigated. Take concerns, comments, or questions from participants on that higher level question or that higher level model, and then go into the concept for calculating fund contributions, again, taking concerns, comments, and questions from participants, and also seeking input from participants on an understanding or estimate of current costs to maintain financial instruments with the Commission under the current decommissioning fund model that uses financial instruments. We will, of course, also save time for other topics from participants, whether those are questions, concerns, or comments. And just to give everyone a brief synopsis of where things will go from here, from the workshop, we will obtain additional written comments from participants. Those can be as to the proposed statutory language, the conceptual plan, or final thoughts or remarks on this proceeding or the workshop today. We intend on providing a proposal to the legislature alongside our proposed revisions to the definition of plant that were discussed in the workshop held on September 22nd in this proceeding. So those are both timed for November 1st. And again, these are legislative recommendations or legislative proposals, they would then be taken up by the legislature if the legislature desires at that point, but they're just going to be provided to them by that date. So any questions or concerns about the agenda itself or considerations that you'd like the commission to take today off that agenda? Okay. So I'll begin briefly with sort of an overview of the concept and why we're approaching it this way, and then take feedback on that if anyone has any before we go into the conceptual plan for calculating the fund contributions. So one element of our consideration in looking at this issue, and many folks who come before us that have decommissioning obligations know that the commission has been undertaking compliance, sort of a large compliance project to bring folks into compliance and to standardize participation in decommissioning, the decommissioning process and decommissioning regulatory oversight process that standardizes it to make it easier and more efficient for folks, but also to make it clear what the obligations are. In part of that evaluation, we've been thinking about the future of renewable energy projects, and batteries, and what will happen at the end of those projects' useful life. And one possibility is that, and what is contemplated by the statute, is that those projects will need to be decommissioned. And we're thinking through if we were to need to call upon one of the funds that currently exists, either a letter of credit, an escrow agreement, a bond, or similar. And then what the commission currently has authorization to do if we're calling on those instruments. And there's a bit of an impossibility here, because assuming we collected those funds, there's not really a what then answer in the statute or otherwise. And so we were trying to think that through. And as we thought that through, we thought about what alternatives or what other ideas would make perhaps more sense. Another consideration is about, security for the state of Vermont, and having a decommissioning fund ensures enough available cash to fund any decommissioning that needs to be handled not by the project owner at the time of the end of the useful life of the project. And often the delinquency associated with, let's say, abandonment of a project or bankruptcy would potentially make the financial instrument process more susceptible to problems or issues at the same time that could implicate the ability for the state to acquire the funding necessary to remove projects that are no longer operating. One thing we've received a lot of feedback on over the last few years is the complexity and inefficiencies of the current system, certainly for developers, and there's associated costs we have been told about. And also for the regulator, for us, in reviewing various financial instruments on a 1 or 3 year cycle, depending on the model, and updating and maintaining those securities. Many financial institutions require those be maintained in original form in paper, and the commission, as many know, has moved to an electronic filing system. So this requires us to maintain a fairly substantial set of paper documents in our offices. Our understanding from some comments that have been filed in the last few years is that the developers are engaging with financial institutions to maintain, update, and secure new financial instruments on, let's say, a 3-year cadence. And at each of those engagements, there's a fee paid to the third-party financial institution to secure the instrument. There can be fees paid to lawyers to engage the commission's regulatory process. And there can be fees paid to sometimes consultants, experts, or even staff of the entities to perform inflation adjustments, to prepare filings, etc. There may also be additional obligations in terms of freezing capital or securing capital investments from financiers of the projects themselves. And then within the commission, of course, as I mentioned, there's staff and attorney time dedicated to maintaining these compliance obligations, reviewing them, and then working with the commissioners on the approval process or rejection process. We, of course, also understand that when there's an iterative regulatory review, that can multiply the costs associated for developers. So if something is rejected, it could then double these costs or at least fractionally increase them. So that's some of the reasoning behind us looking at this issue and thinking it through and thinking about other opportunities. And what we have proposed in the statutory language is a decommissioning fund. This fund is modeled on some of the fund concepts that are most commonly thought of in, I think, the Agency of Natural Resources context. But the decommissioning fund is essentially a pool of upfront contributions collected at the time a CPG holder is given a CPG, or perhaps between receiving a CPG and preparing a site for construction. And the commission, in conjunction with the Vermont Treasurer's Office, maintains that special fund for purposes, in this instance, of decommissioning sites when they're used for electric generation or electric storage facilities. The process is very similar, at least in many ways, with the current process, in the sense that a facility obtains a facility-specific cost estimate for decommissioning in today's dollars. And then the CPG holder contributes a portion of that estimated cost into a fund that's held in escrow by the state. The funds are invested. There are built-in investment models and special funds within the state of Vermont. And then that fund is maintained until a facility reaches the end of its useful life. Assuming that the facility needs to be decommissioned or is going to be decommissioned, and we'll just put an asterisk on the fact that we recognize there are many other possibilities for energy sites at the end of, let's say, their useful life. And we'll put that on a shelf because that's not what the decommissioning fund is for the moment. But if the facility needs to be decommissioned and taken out of operation, you can have different scenarios. A facility owner is still actively involved. Sorry, Mr. Mullet, did you want to say something here? Okay. A facility owner is actively involved on the site. They're managing the site. They arrange for site decommissioning, and upon satisfactory completion of that decommissioning, the commission would release funds to that developer. And that's very equivalent to the status quo, in the sense that if all goes to plan and that occurs, then the commission has provided guidance on what needs to be submitted to demonstrate satisfactory decommissioning. That demonstration occurs and we release the financial instrument. We are no longer the beneficiary of an escrow account or what have you. If the facility owner, however, is missing and is filed for bankruptcy or is insolvent or in any other way is unable or unwilling to perform decommissioning, under the current model, we would attempt to call on the financial instrument, which inherently relies on the financial instrument being actively in place at the time this occurs. In the fund model, it would allow the commission to utilize the funds necessary in the fund account for decommissioning of that site. So whether the facility owner is involved or unavailable, the fund can be called upon, but in the status quo, there may very well be problems that the financial instrument model doesn't contemplate. So that's sort of an overview of our thinking on switching to a fund. And I just want to leave some space here for questions, comments, concerns about the overall model before we turn to the calculation method. Not methodology, but sort of conceptual idea. Yes, Mr. Mullet.
Yes, thank you. And apologize if there's some background noise here, but the rain, having the much needed rain on my skylight is well worth it, I think. Two just, I think, maybe related questions, just really trying to ascertain the commission's thinking without particular opinion on our part right now. But the administration is vested in the chair of the PUC as opposed to the commission more broadly, or the department, or somebody else. And I wanted to understand that, and maybe at least tangentially related, is this modeled after an approach used in any other states? Just trying to understand the commission's kind of overarching thinking on these questions.
I'll take those questions in turn to the best I can.
Please.
The model, so we actually used Vermont statutes to identify the chair as opposed to the entire commission and or as opposed to two different agency entities. I know that the department and the commission are often charged to sort of take care of things individually, but for example, independently, but then feed into one another in administering different functions. But the way that many of the A&R statutes are set up is that the Secretary of the Agency of Natural Resources is the identified sort of authority for administration of their funds and rendering certain decisions. And as I mentioned before, those are all funds that are held in trust via the Treasurer's Office. Some components of them are also managed by the Agency of Commerce and Community Development, depending on the nature of the fund. For example, in the Brownfields area, they have a role because there's a loan component, my understanding is, for some of those funds. There is some importance here that an individual in administering a program can execute things and has the executory authority for the agency, but we'd be interested in, of course, looking at other options or thinking about other options should they be proposed, but that what we've heard so far from those entities is that this is an important function of administering the funds internally in the state. We have done a fairly comprehensive look at other states through certain different mechanisms. We've looked nationally. We've also looked at some of the data coming out of NREL, which seems to be one of the primary authors of 50 state surveys periodically over the last, let's say, 5 to 10 years, and what they're doing about decommissioning and cost estimating. We've also talked with New England, some other New England states, because I think New England's in a different place in the evolution of renewable energy projects in terms of timing than, let's say, the Southwest. We've looked to some examples in the Southwest. We've also reached out to academic institutions to see if they're looking at or modeling any of this. And by and large, there are a couple of uniquenesses in Vermont that make it so we are particularly situated. One major one is that statewide siting of renewable energy facilities exists here, and that we give CPGs. That already puts us in a very small category. Then you have to ask the question of who's administering in the individual states where that happens, the decommissioning obligations. And there are various models for decommissioning obligations, but most of them are not at a statewide level as well. So even if you have some state level permitting process, you do not necessarily have state level decommissioning obligations. In a lot of jurisdictions, they do sort of either divest that authority to the localities or the municipalities. And in certain instances, it's all private agreements with the landowners themselves. And it's not sort of tethered to a permitting process, whether that's at a local level or a state level. So we have looked for as much evidence of different models as we can find. There aren't a ton that are in the same position we are with giving CPGs and the current statutory directive under Section 248 that we ensure the decommissioning of these facilities occurs. I'll also recognize that, like I mentioned a few moments ago, many states are taking a look at what happens when these projects start reaching the end of their useful life, or you might want to call that the end of their economic life. And those questions haven't yet been answered, and in particular haven't yet been answered in New England. They're just starting to be asked. We have been told we're ahead of the curve, and I think that's it's helpful and it's not helpful, but that we're thinking about something that may be beneficial for both developers and for the regulators in this regard. That's what I can provide, I think, at this time.
Thank you. The quality of the response was much better than the quality of the questions, so thank you.
Any other questions or concerns or thoughts, feedback at the higher level before we go into the conceptual calculation document? Okay. If there are, they can come later as well. I just wanted to leave space. So we circulated a memo on September 11th about these workshops. And attached to it was a draft decommissioning fund conceptual plan because we had received a number of comments, which we absolutely anticipated would be a top of mind for most folks, is how would the fund contribution compare to the status quo. So at a high level, we set out 4 steps to establish the fund contribution, which again starts with the cost estimate specific to the particular facility for decommissioning in today's dollars, taking that cost estimate, adjusting for inflation. This conceptual plan uses 30 years. You can look at different analyses of useful life, and again, those usually are actually economic life of projects of this type. And we are principally looking at solar just for the purposes of data. And then using a fixed investment return percentage to determine the amount that we would need to have contributed today to reach that 30-year fully funded decommissioning amount. That amount is the fund fee paid after the CPG is obtained. And then the return amount, as this conceptual model goes into, would be that sort of end of 30-year estimated amount. I'll recognize a couple of other points that are made in this memo, but these are all things that again are just conceptual in nature, but there were 2 assumptions that we made also in response to some of the feedback that we saw in the comments. One is just to clarify that there is no intention at this time to alter the Rule 5900 utility owned versus merchant generator owned facility distinction, meaning the fund wouldn't necessarily target utility owned projects. It would be for merchant generators. And then the size of the facilities in the status quo, decommissioning fund financial instruments are required at 500 above 500 kW. At this time, there's no intention to bring that threshold down. There may very well be openness to bringing it up in this system, but we haven't looked into that to date. So certainly not interested in changing the game for smaller projects and what the costs would be, or the vested costs in terms of decommissioning in that regard. And then the only other component I wanted to mention was the question on what about facilities that are already providing financial instruments that already have certificates of public good. We have just taken a look at some conceptual ideas regarding that. I think the hope would be that this is enticing for various reasons, that we've gotten that part right. And for some projects, that might very well be still enticing if they've already received a CPG and they very well might want to participate in the fund model, in which case we would consider a permissive approach, or if a lot of the feedback is this is very, very workable, I think we would see pretty much 100% adoption, except for very old projects that the math doesn't work out for them to make a contribution now to relieve them of their financial instruments that are in place. So that's a high level on the concept for calculation, and happy to answer questions or talk through any of that.
I would also just throw out, Steph, to supplement what you said, that there are obviously situations where decommissioning is a bit of a negotiation as a proceeding for a CPG develops. And we recognize that. And we recognize that those situations, such as large wind projects, or in the case of Vermont Yankee, a nuclear facility, are very different than a lot of what sort of our examples were based around.
And we have received filings from at least one sort of developer representative in the last couple of years outlining some of the associated costs with the 3 financial instruments the commission typically accepts: letters of credit, escrow agreements, and bonds. So we did dig a bit into that more to try to understand the outline I was giving earlier about the sort of lost capital, the sunk costs invested in participating in, let's say, triennial update to a financial instrument. And our understanding is that there are fees associated each time those updates occur, and then the regulatory compliance costs in terms of time and potentially monetary investment in lawyers, et cetera. And based on those costs, it's our understanding that this model is fairly competitive, if not highly competitive. And so we would like to understand if we got that very wrong or spot on, or perhaps we are not understanding the costs, or that some other model is now available that updates that data we had from a couple of years ago. So that's an area we have curiosity, and I'm happy to take any feedback about that now, but definitely in the written comments, we would appreciate if the developers could tell us about, those costs, because we were hearing a lot of concerns about those costs, and then some outlining about those costs, and we're cognizant of that, and that is motivating in part this approach. Mr. Dowds.
Thank you. I don't have a whole lot of feedback on that right at the moment. We're still querying our members about it. Many of them are very busy trying to lock in tax credit eligibility. But I did want to say that I appreciated the presentation of the conceptual model. I thought it was very clear, and it was exactly what we were asking for. So we're grateful for that. We're going to continue to do some member outreach, and we'll try and get you some feedback on how those costs align. Generally, people are hesitant about change. So I think folks did have some questions or concerns about how this might shift risk, what it would mean particularly for existing projects exiting current financial arrangements. So our comments will certainly lean very heavily in favor of that permissive approach if it's something to continue to pursue. But want to acknowledge that the information you provided has been very helpful, and we'll try and follow up with some more specific information as we're able to collect it from our members.
Great. That's very helpful, and that's our hope, is that this can be a collaboration where the commission is accurately understanding the various components from the developer's perspective when we're making different we're looking at different issues, we're trying to pull different levers and push different buttons so that we're getting it closer to whatever right is. We recognize there's probably this is basically an insurance game against uncertainty, and so we want to recognize that from the sort of financing developer perspective, that has certain elements, and then from our perspective in administrating that system, it has certain elements, and we want to be able to represent those accurately in the process. All right. I'm happy to take any other concerns or topics on this matter, or to conclude our workshop early if this was all folks wanted to cover. Okay, I will conclude the workshop now, and thank you for attending, and thank you for submitting your comments, and we will issue a memo shortly providing a deadline for sort of final comments, but I of course want to emphasize that this is sort of the end of the beginning and not the end of the end.
Thank you.
Thank you. Have a great day,
Thank you.
everyone.
Thanks.
Thank you.